He realized it on a Tuesday, not in court, not in a bank office, not even in front of our friends. He realized it in my driveway, holding a set of keys that no longer worked, with a moving truck idling behind him, and that confident smile sliding off his face. Because the house, the one he bragged about, the one he called our investment, the one he swore he'd take back after the divorce, was never his to reclaim. It was mine, and the day he realized the house was mine was the day his whole story finally collided with the records. My ex-husband's name was Grant Whitaker. He always believed confidence was proof. If he spoke calmly enough, if he smiled at the right people, if he acted like the decision was already made, the world would rearrange itself to match his version. For years it did. Even after the divorce, he kept performing. He told people I was emotional. He told my aunt I didn't understand money. He told anyone who would listen that he'd been generous, that he'd let me stay in the house for a while, because he was such a reasonable man. I didn't argue with him publicly. I didn't correct every rumor. I didn't spend my energy chasing the version of me he was handing out like flyers. I was busy trying to rebuild my life in the place that still felt like the only steady thing I had. Then the first letter arrived. Plain envelope. No drama. Just my name typed in a clean, official font. Harper Lane. I opened it at my kitchen counter, still wearing my work badge, still thinking about deadlines and groceries and the small worries of an ordinary day. The top line hit like a slap. Notice of default. I read it once, twice, 3 times, waiting for my brain to catch up. The letter said the loan on my home was past due, 3 months past due, and if the default wasn't cured, the lender could begin foreclosure. I sat down hard on the chair, because the mortgage was supposed to be handled. We had agreed during the divorce that I would keep the house. I would refinance when I could. Until then, I would pay a set amount and Grant would cover the rest, because he insisted he could manage it, like he managed everything. But when I looked closer, the loan number didn't match our original mortgage. It was a HELOC, a home equity line of credit, and the balance was huge. I called the number at the bottom. The woman who answered had the kind of calm you develop when you spend your days inside other people's panic. She confirmed the account. She confirmed my address. Then she said, "Ma'am, the borrower of record is Mr. Grant Whitaker, and you are listed as a co-borrower." My throat tightened. "No," I said. "That's not possible. I never signed for a HELOC." There was a pause. Keyboard clicks. "We have your signature in the file," she said. "I can email the closing documents." "Send them," I whispered. When the PDF arrived, my hands shook as I scrolled. My name, my signature, on a line labeled borrower. It looked like mine. The way a counterfeit bill looks like real money from across the room. Close up, it was wrong. The loop, the pressure, the rhythm, like someone tracing my identity. I felt cold all the way to my bones. "He forged it," I said out loud to the empty kitchen. And in that moment, everything shifted. Because if Grant could forge my signature to borrow against my home, then the divorce wasn't just an ending. It was a crime scene with a paper trail. I called my friend Janelle, a paralegal who had seen enough human mess to stay practical. She arrived that night with a tote bag of highlighters and a face that told me she'd already decided we were not losing. We spread the documents across my dining table. Janelle tapped the notary stamp. "This," she said, "is where the truth will either live or die. Notaries keep journals. If you weren't there, it should show." I swallowed. Grant knows people. That's why we don't rely on vibes, she said. We rely on records. The next morning, Janelle helped me find an attorney who handled fraud and real estate disputes, Marcus Dyer. He wore worn shoes, carried a legal pad, and looked like a man who had learned not to promise what he couldn't deliver. He asked for everything: the divorce decree, the property settlement, any deed documents, emails, messages, payment records. I slid my thick divorce folder across his desk. Grant had laughed at my folder system. "You and your paperwork," he used to say, like it was a cute flaw. Marcus read quietly, then pointed at one paragraph. "The house," he said, "awarded to you. Grant was required to sign a quitclaim deed to relinquish any interest. Do you have the recorded copy?" I froze. I had the signed copy, the notarized copy, the copy our divorce attorney mailed, but the recorded copy, the one stamped by the county recorder, the one that actually changes the public record, I didn't have it. My stomach flipped. Marcus's eyes sharpened. "We're going to the recorder's office," he said. "Today." The building was fluorescent and tired, full of people holding folders like they were holding their futures. At the counter, the clerk typed my address and frowned. "There are several documents," she said. "Print them," Marcus replied. The stack came out warm from the printer. The original deed, both our names. Then, a quitclaim deed recorded after the divorce. But it wasn't the deed I expected. This one showed me transferring the property to Grant. My name. Giving him the house. My breath left my body. "That's not mine," I whispered. Marcus's voice dropped. "That's a fraudulent deed. Recorded." The clerk glanced at us like she'd seen this kind of shock before and didn't like what it meant. Outside, in the parking lot, I leaned against my car because my legs stopped trusting me. "He took my house on paper," I said. Marcus nodded once. "And if he recorded it, he probably used it to borrow," he said, "which matches your HELOC." The next week was a blur of filings: police report for forgery and identity theft, dispute package to the lender, complaint to the notary commission board, requests for certified copies, a notice of pending action, lis pendens, recorded against the property so Grant couldn't sell or refinance it quietly while we fought. Grant called me on the third day. He didn't start with hello. He started with that sigh he used when he wanted you to feel like you were being inconvenient just by existing. "You're causing trouble," he said. "I'm stopping trouble," I replied. "I never signed that HELOC, and I never signed a deed giving you my house." He chuckled, soft and dismissive. "You're spiraling, Harper. You signed. You were there." "I wasn't," I said, "and I'm not stupid." Silence. Then the voice shift, the one he used to soften you up. "Let's talk this weekend," he said, "like adults." "I'll let my attorney talk," I said, even though it still felt strange to say the words out loud. His tone hardened. "You don't need an attorney," he snapped. "You need to calm down." Then he hung up. 2 days later, he escalated. I received an email from a property management company. Notice to vacate. It claimed Grant was the owner, and I was an unauthorized occupant, required to leave within 72 hours. My skin went hot, then cold. Marcus wasn't surprised. "It's intimidation," he said. "There's due process for eviction. This isn't it, but we respond immediately." He sent a cease and desist letter with the divorce decree and the lis pendens attached, warning the company they were participating in harassment. That night, I changed the locks again, installed cameras, and started a log on my phone titled Grant Every time he called, every email, every letter, every time a strange car idled near the curb. I wasn't doing it to be dramatic. I was doing it because I was done being the person who couldn't prove what she knew. The first court hearing came quickly. A motion Marcus filed for temporary orders to maintain the status quo while the fraud case proceeded. Grant showed up in a tailored suit like he was attending an award ceremony. He smiled at the court staff. He nodded at strangers like he owned the room. When the judge asked why he recorded a deed from me to him, Grant's attorney said it was an agreement between parties. Grant added smoothly, "She signed it. She just regrets it now." Marcus stood and handed the judge certified copies, the police report, and our forensic request for the notary journal. "Your Honor," Marcus said, "this is not regret. This is forgery. Ms. Lane remains in possession, and Mr. Whitaker is attempting to weaponize recorded documents to force her out before the truth can be tested." The judge's eyes narrowed at the competing deeds. "I'm not ordering any change of possession," the judge said. "Ms. Lane remains in the home. Mr. Whitaker is ordered to cease attempts to evict or interfere pending resolution." Grant's smile held barely. In the hallway afterward, he leaned close enough that I could smell his expensive cologne and the anger under it. "You think you won something?" he hissed. "I think you're scared," I said quietly. His eyes flashed. "I'm annoyed." "You should be," I replied, "because the truth is coming." Discovery moved faster than I expected. Once a judge sees dueling deeds and a foreclosure threat, things stop being theoretical. We subpoenaed the HELOC closing agent. We demanded the notary journal. We demanded wire records. And that's when the case stopped feeling like a messy divorce and started feeling like a map. Because the bank produced the disbursement history. The HELOC funds, the money Grant pulled from my home, did not go to repairs, not to a joint account, not to anything that benefited our old life. They went to a brand new account, in the name of a company I had never heard of. Whitaker Capital Solutions, EO, LLC. It sounded like a business, but it felt like a hiding place. Marcus traced it. The LLC had been created online, registered through a service, mail routed through a rented mailbox. Grant had borrowed against the house using my forged signature, then funneled the money into his own entity. Then recorded that entity as a creditor, creating a lien-like story that made it look like the house owed him. A loop, a trap. Paper trying to turn theft into investment. Marcus drew arrows on his legal pad until the whole thing looked like a snake eating its own tail. "He planned it," I whispered. "Yes," Marcus said, "over months, and that matters." We ordered a forensic handwriting analysis. A specialist compared my verified signatures, driver's license, work forms, divorce filings, to the signatures on the HELOC and the deed. The report came back clear. The disputed signatures were simulated, not mine. When Marcus handed it to me, he didn't smile like it was a victory. He smiled like it was a door finally opening. "This," he said, "is what makes judges lean forward." Before we could even schedule trial dates, Grant tried to move the battlefield to my front lawn. One morning, a man in a polo shirt approached my porch with a clipboard. I watched through the camera feed while making coffee, my hand frozen around the mug. He taped a packet to my door, took a photo, and walked away without ringing the bell, like he didn't want a conversation. Just proof he had served something. When I opened the packet, my stomach turned. Unlawful detainer, eviction papers. Grant was claiming he was the rightful owner and that I was refusing to leave after notice. He attached the fraudulent deed as Exhibit A, the same way a magician waves a scarf and hopes no one looks at his hands. For a second, I couldn't breathe. Because even when you know something is fake, seeing it in the language of the court makes your body react like it's real. I called Marcus so fast my fingers fumbled the screen. "This is his next move," Marcus said, voice flat with familiarity. "He's trying to get a quick eviction judgment before the fraud case finishes. We stop it." "How?" I whispered. "Answer filed today. Motion to dismiss." And we show the judge the divorce decree, the competing deeds, the pending fraud action, the police report. Eviction court isn't supposed to decide complicated title disputes. That's his whole gamble. I drove to Marcus's office with the packet on the passenger seat, like it was poisonous. Janelle met me there, already printing forms, already highlighting the exact sentences that mattered. When Marcus filed our response, he also filed something else. A request for an immediate protective order that barred Grant from initiating any eviction proceedings while title was being litigated. The judge granted it within 48 hours. Grant's reaction came in the form of a text message sent from a new number. "You're making me do this. No punctuation, no signature." Like the message itself was supposed to feel inevitable. I didn't respond. I screenshot it, saved it, logged it. The next escalation was quieter and almost worse. Grant began calling people around me. My neighbor across the street, Mrs. Alvarez, knocked on my door one evening, her face tight with concern. "Harper," she said gently. "Grant stopped by." My stomach clenched. What did he want? She held up her phone. "He showed me a deed," she said. "He said you're refusing to leave, and he's worried you're unstable." I felt heat rush to my cheeks, humiliation and anger twisting together. Mrs. Alvarez touched my arm. "I didn't believe him," she said quickly. "I've lived here 10 years. I know you. But I wanted you to know what he's doing." I nodded, throat burning. "Thank you," I managed. After she left, I stood in my hallway and stared at the wall, listening to my own breathing. That was Grant's talent. He didn't just attack your case. He attacked your identity, your credibility, your reputation, until you felt like you had to defend yourself just to exist. Marcus told me, "Let him talk. Every lie he tells creates a witness. Every witness becomes a thread we can pull." So I pulled threads. I asked Linda at work for my building badge logs for the week Grant claimed I signed the HELOC. She printed them without a question and stamped them as certified by HR. I requested my cell phone location history from my carrier. I printed calendar entries and meeting minutes that showed I was in conference rooms, not escrow offices. I didn't enjoy doing it, but I learned to treat my own life like evidence. Then the notary journal arrived. It took weeks and 2 motions to compel, because the closing agent and the lender kept misplacing requests. They weren't protecting me. They were protecting themselves from admitting how easily fraud slips through the cracks. When the journal finally showed up, it wasn't a neat book like you'd imagine. It was a messy binder, a log of signatures and thumbprints and scribbled notes. Marcus sat with it, like he was listening for a heartbeat. "Here," he said, pointing. The entry for the HELOC closing existed. Grant's name was there, with a signature that matched his. Next to it, my name, with a signature that didn't match the way I normally move my pen. And in the space where a notary should note identifying information, the notary had written, "ID copy provided." Not borrower present, not verified in person, copy provided. It was the kind of shortcut that turns legality into theater. Marcus leaned back. This is negligence at best, he said, and at worst, participation. He filed a supplemental complaint against the notary and the closing agent. Not because we needed more enemies, but because we needed leverage. Institutions move when they fear liability. The lender's lawyers responded fast after that. They requested a meeting. I sat in a conference room with Marcus, while 2 bank attorneys and a risk manager joined by video, their faces polite and guarded. They spoke in careful language about disputed signatures and review processes and customer experience, like my life was a broken appliance. Marcus slid the forensic report across the table anyway, along with the notary journal entry. Then he asked one question. If this HELOC is upheld, he said, how do you plan to explain to a jury that you funded it without verifying the co-borrower's identity in person? Silence. The risk manager cleared his throat. We are reviewing, he said. Marcus nodded. Good, he replied. Review quickly, because foreclosure will not proceed while this fraud is pending. And if you try, we will seek an injunction. They ended the meeting with promises and no guarantees. But within days, the foreclosure timeline paused officially. The lender flagged the loan as under investigation. That bought me breathing room. Grant responded by trying to create a different kind of pressure. He filed a motion in the civil case claiming I was wasting the court's time and requesting sanctions, as if he were the victim of my insistence on reality. He also filed an emergency request to access the property for an inspection, claiming the home was being damaged. Marcus's response was a single page attached to a stack of exhibits, a restraining order request, supported by camera footage of Grant lingering near my driveway after dark, supported by the unlawful detainer he tried to push, supported by the text from the new number, supported by Mrs. Alvarez's statement that he was showing deeds to neighbors. The judge granted a temporary protective order that prohibited Grant from coming within a certain distance of the property, contacting me directly, or sending third parties to intimidate me. When Grant was served, he smiled for the process server like it was a photo op. But he violated it anyway, not dramatically, not with shouting. He violated it with a realtor. One afternoon, I received an email from a title company asking me to confirm access for a buyer's appraisal. Buyer. My hands shook as I read it. Grant had listed the house. He had listed my home, where I was living, where my things were, where my locks were changed and my cameras were recording, like it was an empty asset he could flip. Marcus moved fast. He called the title company, sent the lis pendens, sent the protective order, sent the court's temporary findings. Within an hour, the title company replied with a single line. We are terminating this transaction due to unresolved title dispute. Grant's listing disappeared that evening. And I realized something. He wasn't trying to sell. He was trying to scare me with the idea that he could. That night, I didn't sleep. Not because I thought he would win, but because I finally understood the depth of what he was willing to do. In the marriage, his lies had been about image. Now his lies were about property, debt, and the system itself. Marcus prepared me for the deposition. He explained it like training for a storm. Grant will try to bait you, he said. He will try to make you sound uncertain. He will try to talk over you. You will answer only what is asked. You will stay calm. The calm is not for him. It's for the transcript. The deposition took place in a beige conference room with a court reporter and 2 attorneys, and a pitcher of water no one touched. Grant walked in like he belonged there, like the chair had been saved for him. When he saw me, he smiled. Not warmth, not kindness. Control. Marcus started with the deed. Mr. Whitaker, he asked, who prepared this quitclaim deed from Miss Lane to you? Grant shrugged. My attorney. Which attorney? Marcus asked. Grant's smile twitched. I don't remember. Marcus nodded. Who notarized it? Grant said, Regina. Marcus slid over Regina's sworn statement, denying notarization and reporting her stamp stolen. Grant blinked, then leaned back. She must be confused. Marcus didn't react. He asked, Where did Ms. Lane sign it? At my office, Grant said. What time? Marcus asked. Afternoon, Grant replied. What date? Marcus asked. Grant said one date. Marcus compared it to the recorder stamp, then to my work logs, then to the notary journal entry, each contradiction placed gently on the table like a weight. Grant's smile tightened. Then Marcus moved to the HELOC. Grant claimed I was present. Marcus asked specific questions about the room, the order of signatures, the closing agent's name. Grant stumbled, guessing, filling gaps with confidence. The transcript captured every, I don't recall, every probably, every moment his story depended on fog. After the deposition ended, Grant tried to speak to me in the hallway. Marcus stepped between us like a quiet wall. Grant's voice dropped. You're going to lose everything, he said. Marcus didn't raise his voice. Contact her again and I file for contempt, he said. Grant's eyes flashed, and for a heartbeat, I saw something raw. Fear, maybe, or the realization that intimidation only works when no one calls it what it is. The contempt hearing came a week later. The judge listened to Marcus describe the realtor appraisal email, the attempted listing, the neighbor contact, the indirect threats. Grant's attorney argued there was no proof the realtor was acting for Grant. Marcus produced the listing agreement with Grant's signature. The judge stared at it, then at Grant. Mr. Whitaker, the judge said, this court ordered you to stop interfering. You continued. This is contempt. Grant's face went stiff, but his eyes flickered. The judge imposed fines and ordered Grant to pay a part of my attorney's fees immediately. Not later, not if he lost. Immediately. That payment hurt him more than any lecture, because money is the only language Grant believed in. And now the system was speaking it back. By the time the forensic handwriting report arrived, we had built a wall around the case, made of logs, stamps, certified copies, witness statements, and dates that refused to bend. The report simply sealed what we already knew. Not my hand, not my pen, not my signature. Simulated. Grant received a copy through discovery. 2 days later, his attorney requested mediation. Marcus asked me if I wanted to try. I said, only if it's on the record. So we went. Grant arrived wearing a softer version of himself, like he was trying a new costume. He spoke about closure and moving on and cooperation. Then he slid a proposed settlement across the table. It offered to return the house to me if I agreed to assume the HELOC debt. I stared at it. For the mediator. I leaned forward. You for the mediator. I leaned forward. You forged my name, I said, quiet enough to keep the room from turning into theater. You don't get to negotiate like this is a misunderstanding. Grant's eyes narrowed. Prove it. Marcus tapped the forensic report folder. We will, he said. That was the last time Grant tried to look relaxed in a room with me. Because by then, the trap he built was turning into a net around him, and he knew it. Grant didn't lean forward. He ran. A week before our fraud trial date, Marcus called me, and I knew something was wrong before he spoke. Grant filed bankruptcy, he said. My stomach dropped. He did what? Chapter 13, Marcus said. Automatic stay. He's trying to freeze the civil case, force you into a settlement. For a second, everything went silent in my head, like my brain pulled the plug on sound to protect itself. Bankruptcy meant federal court, different rules, different timelines, and Grant loved rule gaps like a magician loves misdirection. He's going to claim the house as his asset, I said, voice small. Yes, Marcus said, and that's where the twist becomes the fight. Because bankruptcy court doesn't care about your feelings. It cares about assets, creditors, claims, and what the record says. Grant thought the fraudulent deed gave him enough record to pull the house into his bankruptcy estate, the way you pull a chair under you before someone else can sit. But we didn't panic. Marcus filed an adversary proceeding in bankruptcy court, a lawsuit inside the bankruptcy, alleging fraud, forgery, and requesting that the transfers be declared void and any debt tied to the fraud be deemed non-dischargeable. He also filed an emergency motion for relief from stay so the civil court could proceed to determine title. The bankruptcy hearing was set fast. Grant arrived with a new attorney, a man who spoke in statutes like he was reading a recipe. Marcus spoke in documents. He presented the police report, the notary complaint, the wire records, the LLC formation, the forensic report. Then he said calmly, "Your Honor, this debtor is not seeking honest relief. He is seeking to freeze a fraud case long enough to exhaust the victim and force surrender." The judge looked at Grant. "Mr. Whitaker," he said, "did Mrs. Lane sign these documents in your presence?" Grant hesitated. "Yes." The judge's eyes narrowed. "Then why does the notary listed deny notarizing and report her stamp stolen?" Grant swallowed. I don't know." The judge turned to Grant's attorney. "Counsel, do you have an explanation?" The attorney began a long speech. The judge held up a hand. "I asked for an explanation, not a performance." Grant's face tightened. The judge ruled from the bench. Limited relief from stay granted. Civil court could proceed to determine title. The adversary proceeding would move forward. Fraud-based claims would not be swept away as easily as Grant hoped. When we walked out, Grant brushed past me, and his voice had none of the old charm. "You're ruining me," he said. I met his eyes. "You did that," I said quietly. "You just thought I'd carry it for you." Trial arrived in early spring. By then I was tired in a way I hadn't known existed, but I was steady, because I had learned something through every escalation. Grant's power was never real. It was borrowed from my silence, from my doubt, from my instinct to keep peace. In court, Marcus didn't turn it into theater. He let the evidence do what evidence does. The notary testified her stamp had been stolen, and she did not notarize my deed. The HELOC closer testified they relied on the notary and did not verify me in person. The handwriting expert testified that the signatures were simulated. Then I testified. I didn't talk about every cruel thing Grant had ever said. I talked about facts, where I was on the day he claimed I signed, what my work logs showed, how I received the default notice, what the signatures looked like, how I never agreed to borrow against the house, how the divorce decree awarded the home to me. Grant testified, too. He tried the old script. "She signed," he said. "She regrets it. She can't afford it. She's being emotional." Then Marcus cross-examined him. "Mr. Whitaker," Marcus asked gently, "if this HELOC was for shared household needs, why were the funds wired to Whitaker Capital Solutions, LLC? Grant blinked. "My business. Investment. In what? Marcus asked. Opportunities, Grant said. Name one, Marcus said. Grant hesitated. Marcus held up the wire record. You opened that account 2 days before the HELOC closed, he said. You wired $186,000 into it. Then you recorded a claim against the house as if your company was a creditor. Explain how that is anything but a loop designed to trap Ms. Lane. Grant's jaw clenched. He looked at the jury, then at the judge, then down at the table like the wood might offer him a new lie. But paper doesn't bend for charm. In closing, Marcus didn't shout. He laid out the timeline like stepping stones that led to only one place. Fraud is not a misunderstanding, he said. It is a choice. The verdict came back that afternoon. The jury found the deed from me to Grant was forged and void. They found the HELOC signature was forged. They found Grant committed fraud. The judge entered an order quieting title, declaring the property belonged solely to me and ordering the fraudulent claim removed. Attorney's fees awarded. The lender, faced with findings, treated the HELOC as fraudulent and rescinded the default. The day the corrected judgment was recorded, the county recorder stamped the chain of title like sealing a wound shut. For the first time in months, my house felt like it could exhale. Grant, however, couldn't accept a quiet ending. 2 weeks later, on that Tuesday, he showed up at my house with a moving truck behind him, clipboard in hand like a man collecting what was always his. My doorbell camera pinged. I watched him through my phone for a second, amazed by the audacity. Then I walked to the door and stepped out onto the porch. He smiled at me like we were old friends. Harper, he said, this has gone on long enough. We should be reasonable. I'm here to get some of my things. And honestly, we both know the house should be sold. We can split it and move on. I stared at him. Then I held up a single certified page, the quiet title judgment, with the recorder's stamp visible at the bottom. His smile flickered. What's that? It's the judgment, I said softly. Recorded. He scoffed. That doesn't... It does, I interrupted, calm. Your deed is void. Your claim is void. You have no interest here. You have no right to enter. And if you step on this property after being told to leave, you're trespassing. The movers shifted awkwardly behind him. One of them looked at Grant like, are we really doing this? Grant's eyes darted to the stamp, the case number, the signature, and for the first time, I saw him lose his footing because his keys didn't work. His voice didn't work. His I'm in control act had nothing to stand on. He swallowed. You can't do this, he said, quieter now. I tilted my head. I already did. He tried to recover, straightening his shoulders, lifting his chin the way he always did when he felt watched. He lowered his voice. If you push this, you'll be the woman who dragged her ex through court. People will talk. I smiled, small, real. I'd rather be the woman who told the truth, I said, than the woman who lived inside your lie. His face tightened. He looked past me at the house like he was seeing it for the first time, not as a prize, but as a locked door. Then he looked down at the keys in his hand, the keys he brought like a symbol, and realized they were useless metal. His shoulders dropped, just a fraction, like a man finally understanding the stage had been taken away. He turned to the movers. Cancel it, he muttered. One of them asked, You sure? Grant didn't answer. He walked to his car. Before he got in, he looked back at me, eyes full of anger and disbelief, and something that looked almost like reluctant respect. And he said, barely audible, You were never as stupid as I told myself. I didn't reply, because I didn't need to. He drove away. The moving truck pulled out behind him. The street went quiet again. I stood on my porch for a moment, breathing in air that felt different. Lighter, like my lungs had been waiting for permission. Then I went inside and closed the door. Not because I was afraid, but because I finally understood something Grant never did. This house wasn't mine because a man allowed it. It was mine because the law said so, and because I refused to let him rewrite reality. That night, I sat at my kitchen table, the same table where I'd opened the notice of default, the same table where fear first flooded me. I placed the recorded judgment into my folder and labeled the tab, Home. Then I whispered, Mine. And I slept, finally, without flinching once, not as a taunt, as a fact. Because the truth, once recorded, is hard to erase. And the day he realized the house was mine was the day I realized my life was mine too.